in the matter of the King on the application of Oakley and the Secretary of State for Justice and the Secretary of State for Justice in Sneddon.
This morning we are handing down our written judgments in these two conjoined appeals. In the normal way, copies of the written judgment are available and will be put up on the National Archives. What follows is a summary of the reasons for our decisions. The summary is provided in order to assist understanding our decision. What follows does not in any way form part of the judgments themselves or the reasons for our decisions. These two conjoined appeals concern the power of the Secretary of State for Justice to transfer prisoners to open prison conditions under Section 12, subsection 2 of the Prison Act 1952. In exercising that power, the Secretary of State can call for advice from the Parole Board. If the Secretary of State does so, it is the duty of the Board to advise the Secretary of State with respect to any matter referred to it by her which is to do with the early release or recall of prisoners. See Section 239, subsection 2 of the Criminal Justice Act 2003. The appeals raise important questions of principle as to the correct approach to be adopted by the Secretary of State to such advice from the Board. In the case of both Robert Sneddon and Carl Oakley, the Secretary of State decided not to accept the Board's advice to transfer the prisoners to open conditions. There have been numerous first instance decisions on the correct approach to be taken by the Secretary of State to the Board's advice, not all of which have spoken with the same voice. The Court of Appeal unanimously allows the appeal against the judgment of Mr. Justice Fordham in the case of Mr. Sneddon and dismisses the appeal against the judgment of His Honour Judge Kayser, King's Counsel, sitting as a Deputy High Court Judge in the case of Mr. Oakley. Our reasons are as follows. The Secretary of State is the primary, indeed sole, decision-maker. See Section 12, subsection 2 of the Prison Act 1952. The Secretary of State is not obliged to consult the Board for advice and is not bound by the advice should the Secretary of State choose to ask for it. The Board has relevant expertise and has been recognised as carrying out a judicial function comprising specialist members who consider often very large volumes of material and hear evidence, all subject to rules of procedural fairness. However, if the Secretary of State does seek advice from the Board provides just that, advice. The Secretary of State must consider the advice of the Board with care and accord it such weight as is appropriate. Nonetheless, the Secretary of State is entitled to reject it if the Secretary of State reasonably concludes that the advice is not wholly persuasive. The Secretary of State is entitled to reject even a reasonable recommendation on the basis of her own reasonable, though different, assessment. Thus, in assessing the lawfulness of the Secretary of State's decision, the exercise is not to identify whether the Secretary of State has relied on a good or a very good reason for departing from a Board assessment. Rather, the question is simply whether or not the Secretary of State's decision was rational, that is to say, reasonable in all the circumstances. The Secretary of State does not have to identify error or deficiency in the Board's findings or reasoning in order lawfully to disagree with the Board's advice. Mr. Justice Fordham's approach fettered the Secretary of State's discretion in a manner not contemplated by Parliament. None of this is to undermine the importance or the value of the work of the Board as an expert advisor to the Secretary of State on the question of prisoner transfer to open conditions when called upon. The Secretary of State must consider the advice of the Board with care and accord it such weight as is appropriate, given the nature, extent, and context of the Board's findings and recommendations. But the statutory scheme is clear. The Secretary of State is the sole decision maker, and the Board acts as advisor. The Board's advice is not binding on the Secretary of State, who has their own independent expertise, nor does the Secretary of State have to identify error or deficiency in the Board's findings or reasoning in order to disagree with the Board's recommendation. What is required of the Secretary of State on the ultimate question of whether to transfer a prisoner to open conditions is a rational, that is to say reasonable, decision in all the circumstances. Following our judgment, we have received an application for permission to appeal by both Mr. Sneddon and Mr. Oakley from our unanimous decisions. We refuse permission to appeal. Beyond that, the order of the court will be made in accordance with the terms agreed between the parties.